With that, we're going to have first paper, Jamal Green's paper. So Jamal, take it away.
Jamal Green, Columbia Law School. Thanks for having me. Thanks, Mike, and all of the colleagues at the center for putting this event on. So this paper is pretty early stage. This draft is the first draft produced. So there's a lot of it could use a lot of help. The basic idea, and I'm going to assume some familiarity with the basic argument, if at least all of you followed the usual practice of skimming the introduction and looking at the conclusion, and then some of you actually read the paper. The basic idea is that we being specifically judges in constitutional cases within the U.S., we use different kinds of constitutional arguments, and we're confronted with different kinds of constitutional provisions. Now, stated in that way, it seems not just intuitive, but maybe something we've known and written about and thought about for a long time. So here's what I mean. I think judges, and this is in some sense a kind of anthropology of judges, but I think judges have an instinct in interpreting constitutional provisions, or at least when they are faced with certain kinds of questions about the Constitution. They have an instinct that varies depending on the kind of constitutional norm that the question is about or raises. When it's the kind of norm that one might anticipate, will require the exercise of judgment of reasonable people in applying that norm to facts on the ground. Judges have an instinct away from originalism towards various more dynamic forms of interpretation, and I'm using originalism as a shorthand. We all know that it means lots of different things depending on how it's defined, but here I mean originalism as a somewhat eclectic methodology that focuses on original understandings or expectations at the time the relevant provision was enacted. And when judges are faced with different kinds of provisions, those provisions where one would not anticipate the exercise of judgment, where to the degree there's disagreement about the meaning, to the degree there's lack of clarity, that disagreement or lack of clarity is unanticipated. Those kinds of provisions, I want to suggest as a positive matter, we tend to see more, and I'll use the shorthand of originalist methods. Now, the claim is not that we use originalist methods for the clear technical provisions of the Constitution and not for others. The important element of the claim, the one that I think distinguishes it, in fact, from what lots of people have said for a long time, is that the universe of what I call in the paper constitutional rules is not limited to clear or technical provisions, but again, goes back to the initial definition of whether one would anticipate the exercise of judgment. So where does this fit into other positive theories of where originalism fits? In broad terms, we can say there are three, very broad terms. One, originalism is never used, at least never used when it matters. I'll associate that with any number of people. David Strauss would be maybe the most obvious and prominent at the moment. And this pushes back against that to the degree that the category of cases in which originalism does matter is broader than provisions that we all understand and are all perfectly clear. To that degree, that this departs from Strauss. Second position, everything's originalism. This doesn't so much necessarily depart from that, insofar as that position is an ideological position about originalism and what originalism means. So it's trying to define originalism as an ideological concept. So I don't have any stake in that debate in this paper. But what I do suggest is that, in part because those kinds of accounts tend to be focused on defending the use of originalism when it's unexpected. So when we're talking about vague more vague or abstract provisions, it tends to actually, I think, leave a little bit of money on the table, insofar as I think that there are more specific provisions in which, as a positive matter, we do see originalism, or a form of originalism. And we should, if we're making a positive claim about constitutional practice, we should care about that. Third position, sometimes we're originalists, sometimes we're not. It doesn't depend on any systematic difference in the kinds of questions that we're asking or the kinds of provisions we observe. It depends on either some ideological predisposition or random chance or what the judge had for breakfast or some other, not necessarily random, but not especially systematic set of judgments. So the claim is that I agree that originalism is not always used, that we're eclectic in the way we approach interpretation, but the claim is that there is some systematicity to that practice. There are several examples in the paper that I'm not going to go through in detail here. I'll just mention two juxtapositions that try to kind of flesh out the intuition here. One is the juxtaposition between Cherokee Nation versus Georgia and, say, McCulloch versus Maryland. In both of those cases, there was a lot of essentially water under the bridge. There was a lot of prior political practice that was that one might think is relevant to the constitutional question, but the way in which Chief Justice Marshall, the burden or the way in which that information contributes to the burden or the presumption in those cases is different. There seems to be I think a fairly strong presumption in favor of practice informing the content of the constitutional norm in McCulloch, and in Cherokee Nation versus Georgia, the fact that there's lots of prior political practice that suggests that the Cherokee Nation is in fact a foreign state is just cause for tragedy. That's just a tragic consequence of the lack of jurisdiction in the case. So that's example one, and one I could say more. But the point is that the court understood itself as answering different kinds of constitutional questions in those cases. One, a question about a standard, the other about a rule. And again, important to note, the paper doesn't make a claim that there's some inherent or imminent sense in which provisions or questions or rules or standards. This is through the lens of the interpreter. The other juxtaposition is Reynolds versus Sims and Westbury versus Sanders, both about districting. One's about state districting, the other's about federal districting, decided the same term by the same majorities, different justices, but writing the majority opinions, but notably because the kind of question the court was answering, right, the claim is because the kind of question the court was answering, you see a form of originalism in one case and no originalism at all in the other. Okay, so the paper tries to make that positive case. That's sort of most of the paper, most of the interesting work of the paper, I think. And then there's a very limited, as Mike says, limited normative defense of this practice. It's limited insofar as I don't think it's conclusive or dispositive. And I think there are lots of good reasons not to be originalists either in rules or standards cases. But one function played by being what I call a rule originalist is that the interpreter avails himself or is able to avail himself of the reasons behind a design choice in favor of rules, which is that the provision is not expected to change in its meaning over time. And that lack of change is important to settlement and coordination. Again, it's a very limited defense, and I could say more about the ways in which it's limited. But the paper then goes on to make a final point about standing, which is I think follows from the limited defense of, again, what I call rule originalism, which is that if the best reason to be somewhat originalist with respect to constitutional rules has something to do with settlement, then the notion that one will not grant institutional standing, for example, to legislatures, for whatever reasons one has, in a case implicating a constitutional rule, and then let practice proceed, and then at the end of the day return to originalism as the way of resolving the dispute, I think is perverse. And so what the paper suggests is that when we're talking about constitutional rules, we have good sort of ex-ante reasons not to let practice play out. When we're talking about standards, we have less good reasons to not let practice play out. And so that should suggest a more liberalized approach to standing in cases involving constitutional rules than in cases involving constitutional standards. But again, that's also quite a qualified case. So I'm happy to get into all of that during Q&A in response to Michael, but that's the basic paper.